warm welcome to you all. In particular, I want to welcome our speaker today, Dr. Herbert Wopen, and I also want to welcome our listeners who are not LPI members. It is great to have you all here. I look very much forward to Herbert's presentation, your questions, and our discussions at the end of this webinar. Today, you will hear about third-party litigation funding. We want to raise the question, how should it be regulated? I am Antje Federke, Secretary General of LPI in Brussels. Before we start, allow me to briefly frame our topic. The overarching subject is third-party litigation funding. This means someone who is not involved in a claim provides funds to a party of a procedure in exchange for remuneration, normally a share in the award. Typically, funding covers the funded party's legal fees and expenses incurred in the proceedings. Sometimes it also covers the other side's costs. In Europe, third-party litigation funding is still fairly new, and in view of its potential to disturb existing litigation arrangements, as well as to create new conflicts of interests, and considering its capacity to enforce claims that would otherwise not have been tried, it is clear that third-party litigation funding raises many questions and stirs also anxieties. What Herbert, our speaker, will talk about in particular is an initiative of the Committee on Legal Affairs of the European Parliament. In June last year, this EP committee presented a request to regulate third-party litigation funding in the EU. The committee referred to a study previously conducted by the research service of the Parliament, and it included a very concrete recommendation. The committee presented a draft directive on the regulation of third-party litigation funding, and this is our subject today. Herbert will outline the content of this draft directive, and he will then explain to us why he supports this initiative. So, and now, before I give the floor to our speaker, I would briefly introduce Dr. Herbert Wopen. Herbert is Director of Legal Policy at the European Justice Forum. He's registered with the bar in Cologne. Herbert earned directorates in Germany and France in civil law procedure, and he has done research at the University of Cologne and at the Center for Socio-Legal Studies of the University of Oxford. Herbert is a connoisseur of the financial sector. He was an operational banker for 15 years and represented Allianz Insurance here in Brussels for 9 years. I am very happy that he speaks to us today in his capacity as expert of procedural law and process financing. So thank you for being here today, Herbert, and please go ahead. The floor is yours.
Well, thank you very much for the opportunity to have this exchange with you on this important topic. Let me first try to give you an overview of what this market is about. The markets reflect to some extent also different legal traditions. While we have a tradition in continental Europe of enforcing the public order via public law and authorities, it has been a strong tradition in common law countries, particularly in the US, to perceive court actions also as a means of enforcing rules of behavior, driven by private attorneys general to have weaker public institutions, but a strong means for private players to enforce the rules of the game. In continental Europe, collective compensation has rather been a supplement to public enforcement, but not the primary means, not a substitute for public authorities in charge. This general perspective on public and private enforcement may be at the foundation of a conspicuous observation we can make on this slide too. And I would like my bar to disappear. Yeah, okay. The big hubs for private commercial litigation funding are the US, the UK, and Australia, which the latter one, which seems to have seen the worst excesses considering the findings of the 422 pages report of December 2020 of the Parliamentary Joint Committee on Corporations and Financial Services on Litigation Funding and the Regulation of the Class Action Industry. And slide 2 also shows that this business is not about peanuts, but about real money awaiting to be invested into litigation. The European Parliament's research service EPRS shows in its long study, Responsible Private Funding of Litigation of March 2021, from which this chart is taken, that the top 8 funders have command over a total capital for investment of 7 billion euros. And there are several dozens more operating in Europe, maybe an estimated close to 100 funders active, some 44 of them in the UK, 24 in the Netherlands, at least 13 in Germany, with others operating in Austria, France, Spain, Portugal, and Ireland. Litigation funding is even advertised as an asset class for investment, which is not correlated to the usual movements of the capital markets. As most funders are not companies who publish their figures, there are only limited opportunities to get information on returns. But the EPRS has collected information from various sources and come to the interesting conclusion that TPLF is even more profitable than investments into hedge funds or private equity, considering the multiples achieved on the capital invested basis, as we can see on slide 3, lower part. And if these figures are disputed by some, you just need to point to the submission the funder Bentham made to the Dutch Ministry of Security and Justice on 14 October 2014 in their consultation regarding the Dutch draft bill on redress of mass damages in a collective action, downloadable from the respective consultation page. There, Bentham Europe reports on page 5 that IMF has historically generated an average 298% gross return on funds investment, a figure which is also quoted in the Voss report. Let's now turn to the Voss report, and I'm here taking slides by Stefan Wood from a recent presentation. The observations of the markets have led Uri MEP Axel Voss of EPP to raise the issue of a need to regulate the activity of third-party litigation funding in the EU in order to protect EU citizens and companies to be unduly taken advantage of without any serious control. This is a legitimate impulse, as extreme rates of return may point to situations of either market failure or even failure of public service. If citizens' renunciation to violence is the correlate of the state's monopoly on the use of force, the state must also ensure effective enforcement of the law across all areas of law, possibly in proportion to the respective threat of harm, but in principle, nevertheless, in a way that does not severely restrict citizens and businesses by the rights to be guaranteed. Turning law enforcement into a business for profit, however, may lead to justice becoming the victim of conflicts of interests. That is, between the interest of the funder to make as large and as quickly a profit as possible on the one hand, and the interest of the beneficiary of the funding on the other hand, to obtain full compensation of the damages owed to him, or whatever else his objective may be. It certainly is not his objective of only being a tool for investment and not the actual main reason for bringing the respective action. That is what Draft Report 2020-2130 INL by Axel Voss, with recommendations to the Commission on Responsible Private Funding of Litigation to the Committee on Legal Affairs is about. Now, what are the main proposals offered to prevent private litigation funding of the various types of litigation to derail from the actual objectives of litigation in the interest of the claims and beneficiaries? The rapporteur Voss sums the tool for achieving these objectives up as follows in the explanatory statement of his report. Quote, its provisions shall safeguard the integrity of our justice system by effectively protecting European citizens from financial exploitation by litigation funders. Ensuring that victims that suffer harm receive adequate compensation is key for the rapporteur. With this report, he wants to create a rule book for a proactive regulation of TPLF, which will help to avoid the problems faced in third countries and which are now starting to occur also in the EU. The rapporteur regards the following points as necessities for the upcoming legislation towards litigation funders. First, an authorization system managed by national supervisory authorities. Second, strong safeguards against conflicts of interest. Third, fiduciary relationship towards claimants. Fourth, capital requirements as well as an obligation to pay adverse costs. Fifth, prohibition to take control over the proceedings or withdraw without clear justification. Sixth, a cap for fees to guarantee fair and proportionate returns for claimants. And seventh, disclosure of TPLF agreement towards the court, the claimants, and the defendant. Some efforts, he continues, have already been made to regulate TPLF. Recognizing the problems that stem from TPLF, Australia has recently introduced a requirement for litigation funders to hold an Australian financial services license. It has also completed a parliamentarian inquiry into the regulation of TPLF in collective redress proceedings, in which some litigation funders, at least Omni Bridgeway, Managing Director and CEO Andrew Saker, have indicated that they would support further regulation in order to improve transparency and confidence in the system. Pending legislation also exists in Canada, in the province of Ontario, where a bill reforming the collective redress regime contains provisions on TPLF. So far, the quote from the rapporteur, from his justification of the proposal. Now, the report has received 327 amendments in the jury committee, and they point to various directions. Some strive to expand the subject matters open for funding of litigation to such topics as environmental matters, human rights, workers' rights, and any other public interest litigation, including Article 9 of the Aarhus Convention. In short, all kinds of proposal of leveraging court decisions rather for exercising political pressure on decision makers and ensuring public participation in decision-making for future decisions, and not so much for providing compensation for injustice of the past. In a similar political vein, some want to completely prohibit third-party funding of investment arbitration procedures, which supposedly multiply the regulatory chilling effect and financial burdens for states of such proceedings, and that its prohibition would protect the ability of states to legislate in the general interest. An approach I definitely do not share, considering my personal experience of various EU member states withdrawing at will subsidies they had promised for investments into renewable energy investments, and for which numerous arbitration awards could only be secured with the support of third-party litigation funding and after the event insurance. Commission and European Court of Justice are taking, if I may make this clear statement here, the wrong exit to a situation where they wish to keep the EU system of legal protection closed and consistent. They should offer instead to arbitration tribunals the possibility to submit relevant questions of EU law to the European Court of Justice, as it apparently is the solution in the South American Association of States comparable to the European Union. And with their current approach to investment protection arbitration, the European Union really endangers the success of investments into climate change, which are so urgently needed. Other proposed amendments to the Voss report encourage the provision of adequate public funding, mentioning specifically legal aid and crowdfunding. Some are concerned that the regulation should not create excessive administrative burdens for member states. Some stress the need to ensure that the identity of the funder, or at least relevant parts of the funding agreements, are known or the opposite, not known at all to the other party as well as to the court, and to ensure confidentiality towards the funder who should not have access to the data in the file without the written consent of the parties. Some amendments request that contractual arrangements on the basis of conditional funding should be considered as void. Some support the approach to create supervision by public authorities as for similar financial services and are concerned about differences between member states due to diverging and not harmonized regulation. Some advocate that the award should always be granted to the claimants first, before the funder receives money, and that the funding cannot be withdrawn throughout the whole litigation. Some even wish to limit the final compensation for funders even stricter than we propose. They would not grant more than 10% of the damages awarded to the funder. The next strict proposal chimes in with our and the Australian proposal to ensure that the beneficiaries are not diluted to less than 70% of the compensation or damages awarded. One proposal even asks that the funder's profit be added to 100% compensation and should be paid fully by the defendant. Some request funders to make a financial deposit equivalent to the amount in dispute or the value litigation with the public fiduciary, or to create a specific insurance fund to cover all the outstanding costs of claimants in a case a litigation funder becomes insolvent. The fund shall be publicly managed and financed through annual fees payable by authorized litigation funders. None, however, mentions legal protection insurance, sadly for you, which is a shortcoming considering the extensive contribution your companies provide, at least in some countries, to protecting consumers' interests. We have discussed the report with several decision makers at EU level and have learned a bit about the prevailing sentiment, which seems to be largely in favor of doing something. Member states, though, seem very reluctant to provide serious support for funding of collective actions, and business is very much concerned of a wave of collective actions coming up. The Commission is not in favor, as it considers the initiative too much as criticism of their rules on funding in the Representative Actions Directive, which, however, is not the primary objective of the VOS proposal. There are too many other situations where funding is applied, particularly in the assignment model cases, which already have existed before the Representative Actions Directive, as can be seen from slide 8. There are the phenomena of legal tech platforms already growing independently of the Representative Actions Directive, and expansive legal services sites like the Netherlands and Portugal, who try to attract collective actions business. See here the Netherlands and Portugal with the almost highest numbers. UK is not a member state anymore. Now, which modifications can be expected due to the amendments from the VOS report? We can only guess a bit. The main issues which are bound to be open for consensus seem to be at least common minimum statutory standards with safeguards for litigation funding, such as authorization and thus a minimum supervision of funders, transparency and disclosure requirements, no undue control by funders over the legal proceedings they fund, and no permission to abandon funded parties except in exceptional and strictly regulated circumstances. Claimants will have to receive a minimum of 60% of the gross settlement of damages, and discretion for judges to decide on the adequacy of legal fees and their distribution is to be expected. We think the Jury Committee will come to a vote sometime in May and could even have plenary vote before the summer break. The Commission proposal, however, will, due to other urgencies like Ukraine, etc., not come forward during the period of this Commission, but rather in the next one, where it might surface around 2024 or 2025, several years, though, ahead of the review point in time for the Representative Actions Directive. Now, what do we think as European Justice Forum of the result? We think it falls short of our expectations. We do not know whether there will be clear conditions to be fulfilled by funders to obtain an authorization. We do not know which scrutiny there will be on the origin of the funds to be used. If you look at letter B, I'm now going through this list here, it does not seem clear whether there will be constant monitoring of the market activity, as is the custom for other financial market service providers, banking, insurance, etc., fund management. C, regarding funding contracts, our concern is that these are often quite complicated to read and understand. So we would like to see in each member state, and possibly at EU level, a center of competence within the judiciary, i.e. the court or judicial organization, which courts can approach for assistance in evaluating the funding contracts, just as the Fonds d'aide aux actions collectives in Quebec is able to do. D, we think further that transparency of the funding agreements should go as far also towards the defendants as letting them know all the details except for those which might be strategically abused by the defendants in an unfair way to avoid a court decision. Speaking in practical terms, the court should have discretion to redact those parts which might be abused by defendants. On E, we think that funders should have no influence whatsoever on litigation conduct or settlement, and not only no undue influence. The profit potential for funders should be regulated more strictly in our view. That is, not more than 25% of total proceeds should serve the compensation of lawyers and funders, and only in the most difficult and challenging situations, an idea which we have taken from the Australian proposal to regulate, these 25% should be reached. The Australians would grant 30% maximum, but not 40%, as the EU legislator seems to be willing to grant. A very important point is letter G for us, that is to ensure that a case like Volkswagen cannot be repeated, where a private settlement took the case out of the court's hands, which had the effect that no court control of legality and fairness of the private settlement was possible anymore. This must be excluded. Funders should furthermore be, letter H, jointly and severally liable for the adverse costs in case the claimant loses the case. The idea proposed of having a guarantee fund in the amendment sounds interesting on top. Last, letter I, as proposed by Professor Bruns in Germany for the transposition of the Representative Actions Directive, a public infrastructure to pay out an award obtained should be a good structural measure to ensure that there are no excessive costs for private settlement structures, which funders would offer anew for each and every new case. Slide 11 shows a comparison made of the various funding options by the funder Nivalion, Thomas Kohlmeier, present here, representing them charmingly at public fora. They concede that private funding is very expensive, only serves cases financially large enough to be of interest to funders, but seem to be interested in a good cooperation with legal protection insurers in order to obtain some synergies. Maybe this forum here can teach me some interesting news on how this might work out for the benefit of both consumers and law-abiding companies. Let me briefly close with a brief comparison of the private litigation offers with a solution we would favor. Slide 12 shows the usual situation of the assignment models, where 25% to 35% or more go to funders, showing here schematically only a very moderate cost of lawyers. Slide 13 finally shows the solution of the Canadian province of Quebec that we would prefer in the interest of both consumers and law-abiding companies. There, only a small slice of each collective action goes into the central fund administered by the Quebec Ministry of Justice and enables this Fonds d'aide aux actions collectives, so the Fund for the Assistance to Collective Actions, FAAC, to get future collective actions going, which are considered to be in the publicly recognized collective interests in damages of the beneficiaries. So thank you very much for your attention, and I'm now looking forward to a lively discussion.
Thank you very much. Well, this was definitely very interesting, and I'm sure that there are some questions and comments in the pipeline on this, because I am sure not everybody shares your opinion and your perspective here. Let me maybe first say something which you didn't, or a position you might not share at all, that nevertheless third-party litigation funding has the potential of facilitating access to justice for claimants, for situations where simply otherwise it would not be possible to pursue. And I think this is something definitely that needs to be said, and that I think most of the people who are listening are sharing with me. So I do not want to be dominating here. I would suggest that whoever is feels that you want to say something, you go ahead. I think it would be most interesting if we really had a discussion on this topic. And maybe, Thomas, you want to go ahead.
Yeah, thank you very much, Antje. And thank you, Dr. Wopen, for your interesting presentation. And rest assured, a few of the topics you mentioned are already addressed and embraced by the small litigation funding industry. But let me start off with a general remark. First, I would wager a bet that I'm not the only one in the audience today that felt reminded of the bias against litigation protection insurance, because when I was with the DRS Rechtsschutzversicherung Munich Re subsidiary, the argument at that time was that legal protection insurance would entice frivolous claims, wasting judicial resources, and legal protection insurance were the bad guys and should be heavily regulated. I think that was unfounded then and is unfounded now. And I would like to contest a few of Dr. Wopen's arguments. I'm not denying everything he's saying. I think Mr. Voss and his team are probably driven by good intentions, but as is often the case, good intentions are not yet good policy. But let's talk about that. As a last general remark, I think it's probably a fairly dangerous road to take to ask for more regulation for industry that are offering access to justice. I think that legal protection insurance is playing a big role here. Third-party funders are, if you will, a small amendment for special situations, taking some of the weight, but calling for regulation is probably not in the industry's best idea. And I mean the legal protection insurance industry. So where to start? I think that the biggest elephant in the room is that there is this notion that funders are swimming in money and are getting crazy rewards. I will not take away too much of your time in contending all the legal arguments, and there is so much to talk about in the Voss initiative. But let's talk about pricing. You all know that third-party litigation funding is not a loan, but an investment, meaning that it's a total risk transfer. Funders are bearing the risk of total loss. For this reason alone, interest rates of banks granting recourse funding or loans or whatever cannot be compared with funders' returns. Instead, the only way to look at this is to understand the key metrics of the capital markets. And capital markets, private equity or venture capital markets are using the internal rate of return, the so-called IRR. And what is that? Please bear in mind that other than insurers, funders are not getting premium upfront, but are waiting, for instance, in follow-on cartel cases, some 8 to 10 years for a return. So taking this into account, the IRR measures the investment's growth rate over the entire duration of the investment and thus reflects a return being received at the end of the investment period. Let me give you an example. If a funder makes an investment of 100 euro in year one and receives a payout of seemingly outrageous 100% at the end of the proceedings, the payout would be in year 10, meaning that the value of the investment would be heavily discounted. In that case, the funder's IRR would be below 10% on an annual basis and not 100% or more. And I'm really at a loss I'm at a loss to explain why neither the researchers of the European study or someone from Mr. Voss's team reached out to funders and having them explain what these seemingly outrageous rates mean. It's simply these, and if you look at Burford's numbers, for instance, you will find that they are earning money. Yes, that's the idea of having a company, but that their gross multiple on capital is 0.4. So that is something I'm more than ready to explain to you, Dr. Wopen, and everyone else who should be interested. But the basic message is the pricing of third-party funding is probably lower than private equity and venture capital, and nobody wants to regulate these industries. One last remark, if I may. There's so much to say about how consumers' interests are protected. What I really find baffling every time, that there is no case known, there is no hard evidence that consumers have been harmed by third-party funding. The Dieselgate emission scandal case is a perfect example that a German household name, a well-respected German company, spent billions to defend and fight against consumers' rights. And with the help of legal protection insurers, some 400,000 German consumers were able to get their right. If they hadn't had insurance, they would have gotten nothing. That is not the effet utile that European law wants. And there are some funders out there having helped the rest of the uninsured consumers. And I can find nothing wrong about that. Third-party funding is typically about other cases, but I can see no fault in helping consumers to their rights. They would have been better advised to buy legal protection insurance in the first place. Yeah, absolutely. But legal protection insurance has coverage exemptions, and sometimes third-party funding is the only means for the small guy to fight back. I simply don't understand the idea why that should be not in the public's interest. And I could ramble on for hours and contend every point, but I would like to turn back to you. But please allow me to, probably at a later stage in this discussion, to explain how legal protection and insurance and third-party funders could work hand in hand, because that was a question Herbert Wopen already has raised. So thank you all for bearing with me so far.
Thank you, Thomas. Maybe Herbert, could you just wait a second? Simon, would you be able to maybe outline a little bit how the cooperation between insurers and third-party funders functions, at least in the UK?
Yeah, of course. I'm in the UK and in the Australian markets as well. The funders, one of the things I think that Dr. Wopen mentioned was the funders' obligation to cover the downside of the litigation, losing the adverse costs, as we have in common law jurisdictions, is almost exclusively they're covered by legal protection insurers through after the event insurance. So it's a significant amount of business, full disclosure, conflict, etc., that we do, which is in partnership with litigation funders. Yeah, and I mean, it's as simple as that. The interaction there is on the after the event. And to Thomas's point, I mean, if everyone in the world had legal protection insurance and it had no exclusions, then we wouldn't need after the event and we wouldn't need funding, I suppose. But the reality of a lot of the after the event that we do is it covers things that wouldn't necessarily be picked up by a normal legal expenses policy, and funding partners with that. I think the only thing I would add, I don't disagree with unsurprisingly, I don't disagree with anything that Thomas said, but I think the other point that gets brought up a lot is this, the consumer only got X% of their damages. I mean, the sort of rather, I suppose it's wide point made there is that the consumer's percentage of the damages that they receive without funding is zero. It starts at zero, and if funding doesn't exist and they don't have the benefit of legal protection insurance already, their recovery of the damages stays at zero. Now, I don't think that funders should be taking 70% of people's damages, etc. And obviously, the funding industry only survives if there's a record of these settlements giving them a good percentage of the damages, they'd expect. And from a funder's perspective, and I'm sure Thomas will know this, if it goes the other way, it is heavily reported. If it goes the way it normally does, which is the vast majority of the damages end up with the claimants, then of course it just rolls through because people like bad news, not good news. I think there was a lot of research done in the Australian market on the report that you mentioned, and I think there was one case that was pointed to. They didn't have funding where there was 85% of damages returned, but it's a complete red herring of a case. And it's I think the interesting thing with the report, and I say this without having read every word of it, is there is a selective use of statistics within it. I say that advisedly, but which is, let's face it, everyone has their own agenda with these things. In the I mean with the Voss report as opposed to with Herbert Wuppenov. So yeah, I mean that's it. That's the extent of how it works together, is we're covering that downside risk, and it works very well with funders. And my view of working with litigation funders is that you have a case that's been vetted and reviewed in a similar way to we would look for the prospects of success. Yeah, and the returns point as well. I think if I could find the litigation funder that really is making 2 or 3 times their money, then I want to invest in them, but I'm not sure they exist. So,
you can invest in them on the stock exchange. Burford Capital is a
I think on mute, sorry.
But Burford is a publicly quoted company. You can invest in them, I think. And the figures Bentham reports, I mean, they are not fantasy. They are not 0.4. They are 300% return. So I mean, why did they report it if it's not correct? That's something I don't understand. I mean, you can calculate this down IRR. Okay, I can intellectually follow what you're talking about, but it doesn't seem to be the evidence. And the EPRS, I mean, if they are so wrong, why don't funders speak up and say, you're saying this business is more profitable than private equity and venture capital, then prove the contrary. Show them why these figures are wrong. I've never seen any evidence. Funders are saying that is wrong, but I don't see any evidence proving it. And on the first point, Antje, you said access to justice. Yeah, they can contribute to that. Agreed. And I have said it implicitly. I've said, yes, I'm in favor. Investor-state disputes would not come to bear if there weren't private funders doing it. And I've experienced that myself. So they certainly have a role to play, because there is this incredible injustice, which the EU astonishingly now supports, to just erase the access to international contracts. So they are saying, we, European Union, we have signed the Energy Charter Treaty, but we do not stand by our word. We now withdraw our consent to agreeing to arbitration on these issues. And we say, just come to the European Court of Justice. They are the only authority who can decide about it. And this is incredible. This is outrageous. Yeah. So this is more or less preparing the largest arbitration case ever against the EU to be introduced in New York or in Geneva, to ensure that all those awards, which are now being expropriated by the European Court of Justice and by the Commission in declaring something as state aid, which is just compensation, yeah? To compensate those expropriations in a new arbitration case against the European Union. So it's very interesting. So I'm not completely adamantly opposed against funders. I think they have a role to play. The question is, under which safeguards? What are the adequate safeguards? And I think there are many who think that this business needs to be more closely monitored and somehow regulated. And that is exactly the proposal of the Voss report. Let's find good rules to deal with that and to make it part of the regulated financial business, as banks are, as insurers are, all for their particular dangers. Insurers must be able to pay, so you need, of course, capital adequacy. Banks, the same, and they have an immense potential for abuse because they can create money. So you have to watch them closely. And I think funders are very closely in the domain of public, of a financial service for the general public. So they should also be accepting some more scrutiny. And maybe they have proposals to make also come to the table with this constructive proposals.
Okay, because before I give the floor to you, Thomas, I just wanted to say I definitely think, as I said before, that funders do play an important role in providing access to justice or facilitating. I think it is maybe nevertheless important to see that certain safeguards are in place. And I think probably, Thomas, you agree with this. It must be sure that there is no funder that is not properly funded, who cannot fill what it promises to the claimant. And what I also think, and this is always a big issue when it comes to legal protection insurance, it is obvious that there are potential conflicts of interest. And I think also in this regard, there must be certain safeguards. What I definitely think, and this is not our place to discuss what or to implement, but I definitely think we must make sure that any regulation does not stop a fairly innovative way of financing in its track. And I think this is what we have to see, and this is maybe what this approach by Voss and his team might be a bit overdoing some aspects, I think. But Thomas, please go ahead.
Thank you, Antje. And again, I think Dr. Wopen has touched upon a few issues we can all agree on. I have a few problems with the methodology, I have to admit, but let me start with the point of capital adequacy. There is no case known where that ever had become a problem since the year 1986. This is actually the year litigation funding started in Europe, in the Netherlands, with what is now Omni Bridgeway. So the industry has been around for some 40 years, and there has been, at least to my knowledge, no case reported where capital adequacy had become a problem. For the major players, this is not a problem because we are all heavily audited by not one, but probably 3 or 4 auditors, making sure that the capital needed to follow through on funded cases is ring-fenced in the interests of investors as well. So but I think that is a case, an issue that can easily be addressed if only policymakers would talk to funders and have a look how they work and let them explain what they do, then probably this aspect would go away. Of course, it's I would say, obligation of a law firm talking to a funder to make sure that the funder has capital adequacy. Ask them, and if you're not happy with what they are telling you, turn to another funder. But the list, I would say, goes on and on. The pricing, Dr. Wopen, it's interesting because we have the numbers actually, and we have a sister company that holds investments in close to 90 litigation funders worldwide. And the overall return, again, key metric being the IRR of capital invested, is in the low 20s. So 15% IRR upwards. This is in an interest rate situation we are in. This is a lot of money, but it's far from outrageous, and it's slightly below what private equity and venture capitalists actually see as rewards. So again, I am totally confident that within businesses that deal with risk transfer, the litigation funding industry is very well placed, slightly below or at least in line with other markets, and nobody has ever called out for regulation on venture capitalists, VC funds. So the ideas that are presented in the Voss report are meeting so many legal stumbling blocks already. Freedom of capital, the subsidiarity principle. We have lots of endorsements from the Commission. We have lots of endorsement from the nations as well. Let's look at Switzerland, look at Austria, look at France, look at the German Federal Court. Everyone's endorsing litigation funding because there are already lots of mechanisms in place protecting consumers' interests. If I were to offer Dr. Wopen an unfair agreement, he could contest that as a consumer on the basis of existing law. So that's nothing new. That goes for banks, that goes for insurers, that certainly goes for funders. I seriously doubt that a small industry as third-party funding, Dr. Wopen mentioned 7 billion in risk-bearing capital. I would say the actual number would be probably something between 9 and there are estimations out there going as high as 20 billion of risk-bearing capacity. It's still a very small industry compared to the turnover of legal protection insurance, okay? But look at the German's life insurance market, who has an annual premium income of some 120 billion a year. I have serious doubts if, since there are no incidents reported, if this actually is a worthwhile endeavor. And my last point, again to you, dear Dr. Wopen, you've been asking how a cooperation between third-party funding and legal protection insurers could look like. Well, it's the main areas of risk third-party funders are looking after is typically not consumer cases, but there are some cases that are big enough that so they could be interesting. Take again the Dieselgate case. Now, at the outset of Dieselgate, legal protection insurers in Germany have been hit very hard by that because there were thousands, if not 100,000 of cases they had to pay out of their balance sheet. Now, but what legal protection insurance also gained from that was a lot of insight how the case was unfolding. So the legal merits of the case became clear after a while, paid for legal protection insurance in their consumers' best interest. So from a funder's perspective, this is a very interesting proposition because if I know the risk of a case, I can price the risk accordingly. And it's an old saying, you, of all people, of course, know this, being a banker. It's simple as that. A low risk case only yields a low return because if it's low risk, I can price it accordingly. If it's a high risk case, I have to ask for a higher return potential. So if legal protection insurers come up with data that would allow an interesting concept, third-party funders assisting legal protection insurers and offering customers who have not that kind of coverage to step in at moderate pricing, or say if you are Allianz or a bigger outfit across Europe and you have millions of insured customers who have motor insurance but have not legal protection insurance, you could tell your own customers asking for help, hey, we have a quick workaround, join legal protection insurance, and there's a waiting period, of course, but in the meantime, we'll help you anyway. And that help could be facilitated by means of third-party funding. And again, I think this would be definitely beneficial for consumers. One last remark, and that goes to you, Simon. it's a very interesting development that I see it that is a rising concept, that insurance concepts and third-party funding seem to be two sides of the same coin, basically. Litigation funding is a liquidity infusion, insurance acting as a cost guard. And we see very interesting developments that insurers are actually insuring third-party funders, insuring the risks of third-party funding at a premium, but that's a clear growth market. And I'm telling you this, Herbert, because this would alleviate your concerns that capital adequacy is a problem. No, it's not, because there is an ever-growing market that funders have the backing of insurers. So, and you certainly have no doubt about the liquidity of the insurance industry. Back to you, Antje, and I'm happy to discuss the night away on every issue that came up today.
I'm sure we could, but Simon, please.
Yeah, I mean, Thomas, you're absolutely right without wishing to disclose business models, but yes, there is there is partnership between funders and insurers, not just for the adverse cost downside. And yes, of course, a funder that lends its rating, its rating agency, A rating, whatever it is, to the funder, provides the protection for that capital. Yes, I mean it exists. I'm careful to say too much because I can never see the full list of everyone who's on here.
Yeah, you don't have to, but again, I think
yeah.
Dr. Wopen has valid points. He raises serious questions.
Yeah.
The basic takeaway for me is, yeah, please don't talk about us, talk to funders and have them explain their business model, and you will find that, I would say, a cool 75% of your concerns are already taken care of. For instance, take the who has control of the case. It's sorry if I say this quite harshly, Dr. Wopen, it's a myth. It's a myth that funder want to exercise control. No, they don't, because they don't have the manpower to do so. A funder looks at the case, does his due diligence, hires legal experts, and if he comes to the conclusion it's a meritorious case, he might invest. And then he's standing at the sidelines watching the game unfold, because otherwise this would open up so many legal questions, the party behind the party, that nobody is actually interfering with litigation. That's a myth. It's simply not, that's not industry standard.
I think,
please bring up one example and let's look at the funding agreement. So, and one last remark, I had the honor to share a few panels with judges who were asked about their opinion if they would want to see funding agreements. And they all kind of went pale and said, don't hand us the litigation funding agreements. That's none of our business. We're not asking if BMW, for instance, is funded by a bank or by their shareholders or by a funder if they litigate against Mercedes-Benz. That's none of our concern. And what this proposal basically is doing, it is derailing the proceedings for no gain at all. Why should the disclosure of a litigation funding agreement, what good would that be in the diesel emissions scandal case? Not at all. Volkswagen would use this to drag out the litigation for another 3 years, thereby stiffening the consumers about their rights, because everyone knows the longer the litigation goes, the lesser the damage they have to pay. So this is really detrimental to consumers' interests. And I hope that we're talking about consumers' interests in the high end of the market, where we typically fund our cases. I would say there is so much legal talent on all sides when a litigation funding agreement is negotiated. That is not worth the time of the European Parliament to have a look at, I would say. Thank you.
think in detail, it's much too short the time right now to go to look at the separate ideas that are included in this recommendation of the European Parliament. But I'm sure that there are definitely points where you wonder whether it's really the place of the EU to regulate procedural law, for example, or to restrict private autonomy, all these kind of things. But I think I want to give Herbert the last again to conclude his presentation, the last word. But I think it's difficult to say, all right, this is an area of business that doesn't need regulation. I'm not sure whether I can subscribe to this. I mean, I've been long enough in the lobby business to know that this, of course, is always what you say. But on the other side, I am convinced that we need to find reasonable regulation. And with this, I would like to give Herbert the floor and maybe say a last word.
Yeah, well, these will not be my final words, so I keep on discussing. But I think, Thomas, I can offer you an example where a judge acting in politics a few days ago said exactly that they were baffled by the litigation funding agreement, that they did not understand and could not agree the way this was drafted because it prevented the party from concluding a settlement which the judge would have recommended. So there are
Have they ever read an insurance contract? Have they ever read an insurance contract? They are not easy to read either.
Yeah, of course, I've read many insurance contracts, but I'm not talking about reading the contract. I'm saying about the proposal or the rule in the contract, in the funding contract, which made it impossible for the party to agree to a settlement in court of a conflict. It was also apparently a Volkswagen case, so that the judge, who's now active in regulation, yeah, as an MEP, said, well, this is not the way this can happen. So there must be these examples. I'm not I haven't experienced it myself. I'm just repeating to you, Thomas, that the world is not as easy as you would like to see it in that respect, and that there will be things to really discuss. And the optics by which I asked the question is the one of an ideal system. And I think that public enforcement of law in the European tradition needs to be also supported by the judiciary and by public institutions. And I think that the Fonds d'Action, Fonds d'aide aux actions collectives in Quebec is an ideal system, how the state can take a position and say, this is about law enforcement, this is about avoiding scandals, and we support meritorious cases which really need to be enforced in the interest of the public. And there also is in Quebec a role for private litigation funders to complement the funding. This fund has already 20 million Canadian dollars, but they will not invest all into one case. They are always willing to accept private assistance from private litigation funders, but they review the contracts also. So they see to it that it's a fair balance. And I think something like that should be the outcome of the discussion at European level. And that's why we're trying to take a position and to challenge you, and we'll be happy to continue discussing.
I wish you good luck with the European countries taking on this responsibility and taking this kind of money into their hands. I'm interested in learning more about this system in Quebec, but it seems to be a completely different approach, which none of the European countries seems to have taken so far, as I can see. And looking at the development of the funds made available for legal aid, I don't think that there is a big chance that this will really prevail. So
That's the misunderstanding, because this fund is really self-financing to the extent that it takes only a small slice of any collective action, so 1%, and that fills the coffers of that fund and does it without charging the public budget. So member states shouldn't be afraid of following such a model, because it provides funds which are paid by those who merit to pay them, that is, the perpetrators, which have been regarded as being justly ordered to pay compensation. But the compensation goes 99% to the damaged persons, and 1% goes to the fund to ensure continuity of enforcement of the law.
okay, looking at the time, I would say we need to come to an end. I will happily learn more about this system in Quebec, and definitely also continue this discussion and going more into detail. In any case, Simon, you wanted to say something, and after that, if there are no questions from the floor, I think we should close this session. Please, Simon.
Thank you. I'm going to make some non-partisan comments, as I feel otherwise I would take away from Dr. Wolpen's excellent presentation, and I don't want to add any more views. I would love to carry this on for many more hours. So I keep writing notes, thinking we need to say this, we should say this. I think it's been very interesting to hear a different view, because I work so much with funders. From my view, the market's very positive, but I think it's interesting that I think someone said, Thomas said, good intentions. I think there is sound intentions behind looking at the market and seeing what can be done to make sure that the consumer is being protected and their best interests are held. I feel that there may be sledgehammer to crack a nut a little in some of those. But I also agree nothing is simple and nothing is black and white. It's a series of grey. So it's going to be very interesting to see how this develops, and I would love to carry on this discussion. Hopefully we'll have many more opportunities to meet, hopefully in The Hague. Thank you so much to everyone for attending, and I think on a more general note that we can see that this Legal Protection International webinars are becoming an excellent forum for discussion and for learning as well, which is the intention. So thank you very much, Angie, for keeping us honest and doing these, and yeah, look forward to many more. Thank you.
Thank you all.
Thank you very much.
In particular, Herbert and Thomas, and stay tuned for the next webinars.
Thank you very much for this.
Thank you.
Yeah.
Okay, bye.
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 Bye-bye.
Thank you. Bye.
Thank you.